Hi everyone. Thanks for making it through the afternoon. What a great day it's been so far. My name's Kelly Sims. I'm the General Manager for Trademarks and Designs at IP Australia, which is the regulator or the administrator of the IP rights system in Australia. We help Aussies benefit from great ideas. Today we're going to do a session, a great panel who I'm going to introduce soon, on IP right, what you should know, need to know and don't know about IP. So I'm going to introduce the panel here first, and then we're going to jump into our questions. There is a second panel of lawyers, of which my three stellar cast here will also be on tomorrow, and I'll tell you about that at the end as well. James Myint is the recent founder of Stirling and Rose, an Australian digital law practice. A firm specialises in strategic advisory, Web3 and proactive advice for emergent tech companies. Alana Kushnir is an art lawyer and advisor based in Melbourne. She is the founder and director of Guestwork Agency, Australia's first dedicated art law and advisory practice, and the principal investigator of the Serpentine Galleries Legal Lab. Amazing. And Susannah on the end. Susannah Wilkinson is global co-head of the digital law group at Herbert Freehills, specialising in emerging tech, including automation, digital asset, AI and smart legal contracts. Welcome everyone, thanks for joining us. We're going to jump straight into and talk a little bit about kind of what are the core IP right concepts and how NFTs actually operate. And I'm going to hand that over to Susannah to start.
Thank you. If we start right at the beginning, what is intellectual property and what's the law's role there? Conscious that we don't have a lot of time, but it's effectively a legal fiction, as a lot of law is. It's a creation that allows the protection or the commercialisation of ideas at its most basic, okay? When we talk about it in the context of NFTs, we can narrow down on a couple of aspects of intellectual property, but the important point to take away is that these legal concepts have evolved over time to deal with the way that technology enables the creation of ideas, records the collection of ideas, and so it's this constantly evolving concept. One of my colleagues who's a specialist in IP had a great example. When the Mona Lisa was originally painted, we didn't have the ability to copy it, so we didn't need copyright to protect the creative genius in that painting. So the law is constantly evolving. There are general categories that fall into the intellectual property rights. We have copyright, we have trademark concepts that protect brand, we have concepts of patents for inventions and processes, and then we have design protections as well. So when we think about NFTs, we need to think about what is it, and fundamentally, what is the opportunity for commercialisation that could be protected, and how do we view that, almost regardless of the technology. But there's a key part about the technology that's really important, and that's that an NFT is effectively a token, a packet of data that points to something. We're talking about pointing to a digital artwork. There is a disconnect between the token and the artwork, and we have to recognise that, because the way that the legal rights attached to the artwork is very different to the way that attached to the token, and we'll probably get onto that in a little bit more detail. So I just want to flag the two key points there, that there's lots of different aspects of intellectual property rights at law. There's how do you get those rights and how do you enforce them, and then there's the reality that a token is effectively a packet of data that is linked to either a real world or a digital asset. So we have to bear that in mind when we're looking at what are the legal rights that we have and how do we enforce them.
Thanks, Susannah. It's a great intro. Anyone else want to make a comment on any of that to start?
Sure, I think there's two parts. There's a jurisdictional perspective. Different jurisdictions have different laws, and I think this is also an issue just in terms of crypto tokens and currencies generally. The laws are obviously very different, and the last few months, and I think the future year, is going to show that the laws really do apply. But be aware of the jurisdiction, because you may not necessarily be captured by what you think. And the second part is every lawyer, when you begin the training, don't look at the actual property. Think about what the actual remedies are. There's no value in property. It's actually really, when something bad happens, what the actual recourse is. And I think this is sort of the lens I look at it from the perspective of an insolvency lawyer. But when we test it on enforcement, if we test it on insolvency, do you actually have what you have? And Susannah raises an amazing point there.
Well, thank you, James.
Well, but it is, in terms of the actual, what you believe is the perceived linkage. There's two things in NFTs in this creative space. And it may not actually, at least in an Australian perspective, and we can probably talk a bit about the UK and the US as well, but it may not be actually what you think it is, especially when you need it the most. Do you actually have the legal remedies that you expect? And it's a bit uncertain.
Thanks, James. Alana, let's jump into the IP issues around when you create an NFT. What do people need to take into consideration? For example, when you create one, what IP rights can you attach to it, transfer, etc.?
Sure. Well, I would say the most natural fit for an NFT is copyright law. It doesn't necessarily mean only copyright law is relevant. It might be trademarks, maybe patents as well. But I'd say copyright law is probably the most natural fit. And the interesting thing about NFTs is the way in which copyright law can apply to NFTs. And that's because, at least from a copyright law perspective, you can think of the NFT like a layered cake. And at your base level, at that code level, where it is that token, copyright can attach to that. And copyright law would actually consider that code as a literary work. So there's a specific definition of a literary work in the Copyright Act which tells us that computer code can actually be recognised and protected and enforced as a literary work. So that's your base layer. Then on top of that, you obviously have the digital file that the NFT points to, and that digital file, as you know, it could be an image that's in the form of a JPEG. It could be an MP3. It's a piece of music. It could be what we call in copyright law a cinematographic film, otherwise known as a video or a movie with sound and moving images. And so copyright law can protect an NFT at that level too. And the interesting thing is, because you have these different layers of copyright that can each be owned by different people. So you could have one person that owns the code to an NFT, and you can have another person that owns the artwork. So when you're creating an NFT, it's important to think about who out there might actually have authored that NFT and at what level, and that will help determine who can then enforce their rights and have a potential remedy.
Thanks, Alana. So, Susannah, now that we've created the NFT, what are some of the IP issues around when you use it?
Yeah, well, I think Alana gave a really great summary there. So the idea that the person issuing or minting the token may not actually hold the legal rights to the IP or the copyright in the image that is associated with that token. So there's a concept of, as these tokens are transferred, what is the bundle of rights that was established at the outset by the person issuing that token? Did they actually have the rights to issue what they're purporting to issue to begin with? And if they did, do those rights transfer? And there are certain requirements, certain transfer of IP rights might need to be recorded in writing, and there's a whole lot of other complicated parts that come around that. So I think the key question, without getting too much into the weeds, is being very clear about the rights as they were issued, and then understanding how those rights may or may not effectively be transferred through subsequent trades, or dealings with that particular token. And that can be fairly difficult to unpack. But going back to James's point, what is the risk there? What are we trying to enforce, and what is the potential harm? Worst case scenario, maybe you don't get the right for commercial reproduction of those images that you thought you were buying when you bought the NFT. But actually, if you're buying the NFT to display for your own personal use, maybe that's not a problem. So it really depends on what you're in it for, and unpacking the sort of the layers of rights, and looking at that enforcement piece.
Susannah. James, you alluded to this a bit earlier, but let's get into a bit of Australia versus the US, and kind of, aspects that might be the same, different as it relates to IP issues for NFTs.
Sure, and we've touched upon it, but this is the part I love, and I'll just go into what we really have in Australia. Look, it's been touched. Like, the main IP you'll have is copyright. The only way you can actually transfer IP, and this is an assignment, as Susannah said, it requires in writing transfer. You can't escape it. And so we have the A16Z terms coming from Andrews and Horowitz saying we have all these licenses. It won't really, from an Australian perspective, it won't transfer the copyright. They do it through a smart contract. Doesn't really work because you need it to be in writing. That's just a legal formality that's required in Australia. The other way you can do it is you do a license, and you can license it in Australia. So you have the copyright, maybe it's an artwork, and then you license the creator of it, the author, licenses it. And I think one really important thing to think of is an NFT in the sense that we're talking about. It's really a stapled asset. It's a property in the sense of the crypto token, which is the NFT, which is proven to be an asset. Osborne and Persons Unknown 2022, that case decided that, that's pretty clear. But then it's stapled to something else, often a license. The part that's really tricky, and this is why I say think about what if something goes wrong. If the actual issuer of the NFT goes bust and it goes insolvent, as FTX is showing, what actually happens to those rights on insolvency? And that's actually quite problematic, because what actually really will happen is your NFT, that's a property, that you've got that. You will keep that. That belongs to you. But then remember that the NFT is actually a stapled asset. It's stapled to a license, most likely. What happens with your license, which is a contractual agreement? If there's an administrator appointed, they don't really get the right to disclaim it. But what they can actually do is they decide, you know what, we're going to terminate your IP license agreement. Keep your crypto token, but the actual license you have to exploit it or to use it, we're just going to cancel that contract. And if you have a complaint about it, you can join the queue of creditors as unsecured creditors in the insolvency, and they rank quite low. So you may have the token, you have the crypto token on whatever platform you have, but you actually may not have the license. If the issuer goes into liquidation, then the same analysis follows, but a liquidator actually has the right to completely disclaim the contract. So you can see you actually start having these shaky concepts, which you need to start applying the worst case scenario lens to see what you have. Really easy with a car, really easy with a house. But what do you do when you're having these stapled assets? And that kind of analysis, I think the market is starting to realize this, but it's that kind of really technical, bad. We always call insolvency lawyers like the bad lawyers because we do the back end stuff, but it is testing actually what happens. And those are sort of the realities and parameters of Australian insolvency and bankruptcy law in an NFT IP setting. It's an intersection of all of it.
Thanks, James. So now that we've kind of identified, I guess, some of the initial concepts, I want to kind of pose a question for everyone. And Alana, I want to start with you. How can trademark or brand management strategies that are designed for the physical world, the Web 2 world, rather than the Web 3 world, accommodate the challenges that exist in the metaverse where IP is everywhere? And also, how do you defend trademarks and NFTs in that virtual world?
A question for me. I thought, the interesting thing about trademarks, so trademarks in Australia is a registration-based system. And the way in which you gain your intellectual property rights in your trademark is by registering them. So you have to apply and you have to register. So I think, the blockchain and NFTs in particular are quite an interesting use case for a registration-based IP system like trademarks. And like we've also seen with the A16Z copyright licenses, which again are using licenses in a token-based form. So it's really interesting to think about how we can also, think about the relationship between intellectual property law and blockchain reverse, or how blockchain technology can actually support intellectual property law, support the gaining of rights in the space, and then the enforcement of those rights as well.
Can I just jump in there as well? I think you raise a really interesting point, which is around if you take a trademark, my understanding is that the registration process can take a number of months, possibly 7 months, and then you've got you have to publish that for a couple of months and people have an opportunity to object. 7, 8, 9 months is a lifetime in NFT space. Like that's what's the role of law, and are there other angles? There's rights at common law to protect sort of passing off, and there are other, if you don't have that registration, what's the fallback position for the protection of the law and the enforcement to protect that kind of commercial interest? But what's the role in technology? And you touched on this, and maybe we'll come to it as well. How can we use the technology to help modernise the application of law and to actually solve for the challenge that the laws are out there to try and solve for? Because in the context of some of you developers and builders out there who are trying to spin off an NFT project to register those things, it's a very long and cumbersome process. And once you've got that registration, it just shortcuts some of your enforcement sort of rights at the time.
Thanks.
I would add to that also just to note that, again, with licenses, when you grant licenses to NFTs, there's no central way in which you can work out who has the license, the permission to do what. So again, using a technology where it is a public ledger, where everyone could see who has the right to do what, I think it's a great example of how in the future we'll see licenses evolve.
James, any thoughts on that discussion?
Completely agree. Much in the same way you see sort of the movement from ERC20 being the dominant standard on Ethereum, and then moving to ERC721, which you can actually see property transfer rights. I think there's an evolution in the tokens, but I think the thing I find really fascinating is the on-chain linking of the licenses to the NFT. They are two separate things. I think the challenge is, and there's been commentary in the market for the last year, that you can somehow have an independent ecosystem of NFTs independent of the law. The part that I think there are really meaningful and really interesting projects out there in terms of on-chain or on-token solutions. One thing to note though is it is, again, this is sort of the jurisdictional lens I was saying. In the UK, for instance, if you're going to do a transfer of a license, you actually may need to do a registration. And so you may actually need to do that, but the registration, as alluded, goes through this process with an external office. So you may have solutions, you may build license terms like A16Z on the smart contract into the NFT itself to try to deal with the licensing challenge. Sorry, this is transfer of copyright, but you say in the UK, if you try to go through the relevant office, you actually still need to do a separate transfer at the actual governmental office, so it's meaningless. And so the stapling of the real world and the stapling of the NFT token itself, you start seeing a divergence. And one of the worries I really have is just harm to consumers, but also there is the scope for regulatory arbitrage. You can actually be pretty clever. Humans, bad actors, not even bad actors, are quite clever at seeing ways you can exploit that. But it has to move in sync, and you probably need to actually bring in the government of various countries to actually have the harmonized regime. Otherwise, you have those arbitrage opportunities.
Any comments, Susannah, on that? I thought you were about to jump in, but no.
No, I'm just rejoicing in the fact that we're like the biggest party poopers of the entire festival. Is anyone feeling a little down around about now?
No, I think this space is going to evolve, and I think you sort of have Gen 1 digital assets, which they're just transferring value, but we're starting to see people in the generation 2. We're building we're trying to solve. The community is trying to solve for these legal and economic problems in the actual asset itself, and there is that gradual evolution. I don't know what happens Gen 2, Gen 3 beyond, but I'm very, very supportive of the space because people are very clever and they will find a solution, but it does need the full stakeholder management of the ecosystem in terms of the crypto, but also the digital asset, but also externally the real world and the legal systems. Unfortunately, we will still have a place to play.
No, and I completely agree. And I guess the call out, the shout out to the clever people who are building is to help find these solutions. So don't bury your head in the sand and assume that there are no legal challenges. There are challenges, but we need to find ways to solve for those challenges. And the law is incredibly robust and will evolve. But we need people to come to the party and help find those solutions.
I think that's a good segue, Alana, into a bit of a discussion around what is some opportunities around the way we can use technology, policy and the law together to, capitalise on the opportunity.
So there are a few projects that are coming from the open source community and also more commercially oriented projects which are looking at standardising licenses with respect to NFT. So, I think we're all aware of the general public confusion around what rights you have when you buy an NFT and what you can do with that. So there are a lot of interesting projects that are looking at how do we make these standards so that the general public can understand in a more simple way, in a more user-friendly way, what it is that they have the right to do with the asset, the digital asset that they purchase or that's transferred to them. So the A16Z is an interesting model. It's an open source concept, so it can be built upon as well, but they've essentially created these 6 standardized licenses, very much designed in the form of the Creative Commons licensing system, which has been around for a good 20 years. The idea is you can just kind of tack on one of these licenses to your NFTs, and there's actually a line of code that you can build into your smart contract, which will be able to tell anybody who looks at that smart contract code what license is attached to that NFT. It's not the be-all and end-all solution, though. So something that is not quite clear, or at least they haven't really built at the infrastructure of these licenses, is that transparency over which licenses are live, which ones are revoked, which one, which wallet owns what license or has the rights to what license. So that's kind of the next level. There is another standardising project that's being run by Koala, the Coalition of Automated Legal Applications, and you might have heard about their model law that was released last year. And there's a project led by Primavera De Filippi. I'm very fortunate, so I should say I've been involved in this project to bring together technologists, IP lawyers, academics, all looking at, again, this question of how you standardise the licenses. And so there are 2 Ethereum standards that have been published, which sort of go one step further than the A16Z licenses, in that you can actually see there's a kind of a data tree of licenses that attaches to that NFT. So you can actually see which licenses are live. And so there's that as well. There's also the Remastered crew in the US, which they just did a really great podcast for overpriced JPEGs, a couple of sessions on IP and the law. So for any of you that are interested in looking at these issues further, that's a great place to start. So there's a lot of interesting opportunities. There's also the Australia Council for the Arts and RMIT Blockchain Innovation Hub. I've just released a report on the developments of Web3 in Australia, particularly in the creative fields, and that's really kind of looking to map the scene. So that's also one to check out as well to see what's happening in the space.
Thanks, Alana. Susannah or James, any thoughts on opportunities re technology, law and policy?
I think we've covered quite a few of the key ones. I think what's really interesting about that sort of progression you mentioned is that to really recognise the status quo at the moment is that the token and the underlying, let's call it the digital file in this instance, those things, that the way that they're traded, maybe there's some simple terms and conditions on the website, the marketplace where the NFT is purchased, but that doesn't necessarily track with the token. So it is really important to get that connectivity or the continuity with where the token goes, and clarity around what those terms are, because you can't really be bound by terms unless you are aware of them. So I just think it's understanding sort of the process and the evolution we need to go through is probably my key message there. But yeah, as Alana said.
I think, look, the NFTs, they form part of a broader digital asset ecosystem. I'm most fascinated. We spend a lot of time looking at the nature of digital assets and how they develop. In terms of from a property, IP, insolvency perspective, there's a lot of material that we've produced. I think the really fascinating part I find with IP law is actually we see a potential model where you actually expand the scope of intellectual property to cover digital assets, and you actually see some really clever thinking in terms of existing law to extend it. Like the intention, like the law is commercial, it does follow practice, and I think it will follow into the space. I do think that half the solution, as alluded to earlier, is a technological one, but I think it's actually, we're still going to build on the biggest, baddest centralized institution of them all, which is the legal system. But we have to slowly and carefully knit it together. But the example I've given about how your licenses may actually be quite worthless in relation to the NFT on insolvency, that's something that no one's really thought about. But it is there, and it is going to just exist because it's a function of how insolvency works. So I think watch this space, but keep building.
Susannah, I wondered if you'd just provide a bit of info on the Digital Law Association and what their aspect is for this topic around NFTs, metaverse and other things.
So the Digital Law Association is a not-for-profit association aimed at bringing sort of diversity into the voice of this intersection of law and tech and policy. So we create a platform for our members to have a voice. So it's not that we dictate a particular position, but we provide an opportunity for people who are interested in these topics to come forward and participate in consultations and other things where they otherwise wouldn't have an opportunity. So all of the issues that we're talking about here are front of mind for either technologists or lawyers, academics, trying to grapple with the way to harness the benefits of the law and the protection. Law is there as a sword and a shield, but we need to really lean into it, and we need the clever people who are out there at the coalface to engage in those concepts.
Thanks. I think we have about 2 minutes left. Rochelle's giving me the wind-up sign here. I thought we might leave everyone just with perhaps your top tip in this topic, IP right, what you should know, need to know and don't know about IP, the take-home for everyone. Alana, we'll start with you.
So don't assume that you have IP rights in your NFT. It really depends very much on a case-by-case basis.
Thanks. James?
I think the interesting thing is this is a decentralized space, but humans still tend to have the need to. We trust people because we had a beer with them, and we trust certain people because they have a certain brand around them. But I think it's caveat emptor, just be really skeptical. Read the terms and conditions and really think what you're actually getting into, and just don't assume that because it's like what a certain personality says or what the US position is that it's going to be necessarily different or the same in Australia. Just be very skeptical and read the TNCs.
James, Susannah.
I think probably that the law is robust and can be very useful. It can be complicated, so go in eyes wide open, but know what you're trying to achieve, and then figure out the best way to use the law to get that outcome.
Thanks, Susannah. And from the IP Australia point of view, we're just really interested to have you engage with us, to hear from people on different perspectives. We follow the law, so we're looking to see what the law does in this area, but we're also trialling new things. So one of the things we are trialling is a new AI-enabled tool. So everyone here, please go have a look at it, tmchecker.ipaustralia.gov.au. We're in pilot. We're, just around the trademark subject. We'd love for you to engage with it. And finally, tomorrow, Alana, Susannah and James, and I think 3 other lawyers will be on a super panel, 10 a.m. in the Vault, called Can I Pick Your Brain? So hopefully please reflect on our discussion and take your questions to them all tomorrow. Thanks so much. Have a great evening.
Thanks, Kelly. Thanks,
Thank
everyone.
you.